All right. Court is going to call 2016 CR 4781 State versus RC Curtis. Can I have parties announced?
Daryl Harris, Steve Spear, and Alexandria Boggess for the state attorney.
And for the defense?
Charles Buck and Lucy Shaw for my client RC Curtis.
And are you Mr. Curtis?
Yes, ma'am.
Are both parties prepared to proceed?
State's prepared to proceed with jury selection, Your Honor.
Yes, Judge.
And defense, have you received all discovery?
As far as I know.
All right.
And
Just follow them. Number 8,
yes.
second row, on top. Have a seat. Once you find your chair, please have a seat. $15 on the bench. $22,
20.
next row.
All right, good afternoon, everyone. All right, that's a slow reaction time, so we're gonna work on that. And it's very low. Good afternoon, everyone. Welcome to the 187 District Court. You are on the fourth floor in the 187 District Court, and the judge is Judge Stephanie Boyd. So what floor are we on? What's the court number?
187.
And who is the judge? All right, now I know what you're probably thinking to yourself. Where have I landed? Why is she asking us these questions? We obviously know where we are because here we are. The reason why I asked that question is based upon experience. Whenever we have a break, what ends up happening is everyone has to leave the courtroom when we take a break. And it never fails that someone ends up getting lost. They will say, I looked up, everyone was gone. I had no idea where the courtroom was. So if you remember the fourth floor, you may be able to find us. If you remember the 187th District Court, you'll be able to find us because 187th is just signifies that this was the 187th court created in all of Texas. So there is only 187th District Court in all of Texas, and that is this one. If you cannot remember that, if you remember Stephanie Boyd or the last name Boyd, I am the only Boyd that's in the courthouse. So anyone will be able to tell you where you need to be if you get lost. Now, to my left is the court reporter. I always said if ever I were in a position to make somebody's job easier, I would do that. So we're in jury trial in this court almost every single week without fail. I have asked everybody to make the court reporter's job easier. So far, every jury panel has failed to do that. So before I ask you what you need to do, will you all promise me that you're going to make the court reporter's job easy?
Yeah.
This is how you do that. So can everyone in the back hear me?
Yeah.
This is the level you need to keep your voice at. Do not think, oh my gosh, I'm talking too loud. If you're talking too loud, someone will tell you, you're talking too loud. Never happened because people always whisper. Now, you have something very important in your possession that is very valuable. They're cards with your number on them. So everyone, if you can, raise your card with your numbers facing me. Now, this is the part. Oh, this. Yes, yes. You're getting there. We have one more person, number 18.
I hear somewhere.
You're probably sitting on it.
Oh, I meant the card.
That's okay. So this is the part where juries fail at, but I think you guys can do this. I'm going to tell you what I tell them. I have faith that you will make the court reporter's job easier. So hold your card up. Don't lower it in until I ask you to. Jurors 1 through 21, lower your cards. Everyone else. All right, juror number 22, keep your card up. Everyone else, if somebody addresses you and you want to answer that question, you need to stand. Can everyone do that?
Yes.
Do you promise me that you will do that?
Yes.
All right, you may lower your cards. And to the attorneys, when you're addressing the jurors to help the court reporter out, do not stand in front of the juror that you're addressing because, believe it or not, it makes it easier for her to hear. Now, this is the state of Texas versus R.C. Curtis. You're in a courtroom that handles criminal cases. I'm going to have the parties introduce themselves to you. For the state.
Good afternoon, ladies and gentlemen. My name is Daryl Harris.
Hello, folks. My name is Steven Spear.
Hi, I'm Alexandria Bogus.
All right, and for the defense.
Hi, I'm Charles Bunk. This is Lindsay Shaw.
This is R.C. Curtis.
Thank you. All right, now, sometimes in this courtroom, there are people who come in. They are not associated with the case. They're coming in to learn. Sometimes we have brand new attorneys who want to learn. Sometimes we have students who are in law school or thinking about working in the legal field. So what ends up happening, they go throughout the courthouse and they say, who is at trial? And they may come in to see what's going on. If you see someone coming through that door, it's because they did not read the sign on the outside the door that says, do not come through here, we're in a jury trial. So you will still see people come in, they may stop and stare in shock, close the door. It's absolutely nothing to do with this case. If you see people coming through this door, it's for me, it's probably orders or something for me to sign. But again, it has nothing to do with this case. Does everyone understand?
Yes.
All right, so you've had a chance to see the parties as they stood. Raise your card if anyone recognizes any of the parties that have just introduced themselves to you. Anyone from the state, anyone from the defense, or Mr. Curtis. All right, juror number 29, anyone else? All right, so we're gonna see if we can remember the rules. Juror number 29, who do you recognize?
Daryl Harris.
And how do you know Mr. Harris?
I've had conversations with him. I'm a police officer.
Right, thank you. Now, what I'm going to talk to you about now is the charge in this case. The charge in this case is capital murder. And I'm going to come back around to circle to that, because first time when people hear the words capital murder, they're thinking about punishment. What's the range of punishment? So I'm going to get back to that with you in a second. This is what I'm going to tell you. Neither the state nor the defense can tell you what they think the facts are in this case. The only way you will know what anybody thinks the facts are in this case is if you are selected on the jury trial. So whenever you hear something or somebody's asking your questions, don't be like Mrs. Kravitz in Bewitched and saying, oh, so those are the facts of this case. You will not know what people think the facts of this case are until you're sworn in and there are 12 people in the jury box. Does everyone understand?
Yes.
I want to talk to you about an indictment. What is an indictment? An indictment is just a piece of paper. It's what's needed in order for someone to be brought to trial in a felony case. So an indictment will just give somebody notice. It'll tell you what you're being accused of and where you need to be to have a jury trial. Does everyone understand?
Yes.
It's not evidence of guilt. It cannot be taken to mean anything. Does everyone understand?
Yes.
Now, raise your card. We're going to practice. If you've ever had a traffic ticket before. Oh my gosh, San Antonio continues to have horrible drivers. Well, we've all learned from those. Okay, lower your card. I've had a traffic ticket before once. I think I was maybe 19 or 20. Here I am, 22, right? So anyway, let's assume that you've received a traffic ticket. And let's say that traffic ticket, an officer pulls you over and an officer says you ran a stop sign, that you didn't come to a full stop. Thank you. That you didn't come to a full stop. Now, they will give you a ticket. Back in the day, when I got my ticket, they had a carbon copy. They would tear off one, give it to you. And on that sheet of paper, it will tell you what they're accusing you of doing. So in this hypothetical, running a stop sign, it'll tell you, hey, come to municipal court if you want a trial, or either this is where you can send your payment in, right? So if you decide to go to municipal court and tell them, hey, I want a jury trial, you get your jury trial. However, when you receive that ticket is not evidence of guilt. And when you get that ticket, it's not by your accepting it, you're not telling the officer, yeah, you're right, I ran a stop sign. It's just to give you notice. Because it would be very odd and difficult for you if you get a ticket for running a stop sign, and then when you get to municipal court, they say, aha, you ran a red light. That's what we're here for. So that is all an indictment is. It's just a piece of paper to let you know what you're being accused of. Does everyone understand?
Yes.
And then sometimes people will say, well, if somebody has been indicted, it must mean that they've done something wrong, right? People have said that before. But let me just tell you, in criminal law, in the legal system, in the United States, you cannot hold it against a person because they've been indicted. You cannot take that indictment to mean anything. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Curtis or assume just because he's indicted that he's done something wrong?
No.
Now, the other things are rights that defendants have. One of them is called the right to remain silent. Has everybody heard of that? You've heard it probably from Mannix, Beretta, Paper Chase, The Practice. All right. So what does that really mean? What that means is in criminal cases, the state cannot call your client, if you're a defense attorney, they cannot call them to testify. They cannot say, hey, my next witness is going to be the person who's accused. They're not allowed to do it. Whether or not someone is accused of a crime, testifies, is completely up to that person, whether they want to or not. Does everyone understand?
Yes.
There are many reasons why somebody may choose not to testify. I've been a defense attorney. I've been a prosecutor. When I was a defense attorney, sometimes I would meet with my client in the office and I would say, hey, you're sweating and I'm the only person talking to you. And I believe that you didn't do this. Probably wouldn't be good for you to testify because jurors may say, oh my gosh, this person is sweating. Obviously they're guilty. Sometimes you would have a client who would have a speech impediment. And then sometimes people are just so afraid of public speaking because you're sitting in a box, you've been sworn in, and everybody's staring at you. So there may be many reasons why people don't testify. And I've had jurors before, they would say, well, if that were me, I would testify. And I always say, it's easy for you to say that because it's not you. So when you think of attorneys, think of them like doctors. When you go to a doctor and a doctor tells you this is the course of treatment you should take, how many people say, well, I know you're saying that's my course of treatment, but I'm completely 100% ignoring that. And 4 of the doctors have told me this is my course of treatment, but I'm just going to go out on a limb and do what I want to do. It's the same thing. Sometimes clients receive advice. I would have clients sometimes, I would say, state and prove their case. There's no need for you to testify. So the key factor is, and a person who's accused of an offense does not have to testify if they don't want to. And not testifying means they're exercising their right to remain silent. Does everyone understand?
Yes.
Is there anyone here who will hold it against Mr. Curtis if he decides he's not going to testify? Raise your card if that is you. Now, the next thing I want to talk to you is about presumption of innocence. Everybody who's charged with a criminal offense is presumed to be innocent. What does that mean? That means that unless and until the state proves their case by proving every element of their case beyond a reasonable doubt, the presumption of innocence is alone to acquit somebody. So, presumption of innocence means until you hear evidence that overcomes the presumption of innocence, then that person is not guilty. Does everyone understand?
Yes.
So right now, how much evidence have you heard in this case? So if you had to vote right now, knowing that Mr. Curtis is presumed to be innocent of what he's been charged with, what should your vote be? Thank you. Now, I want to talk to you about burden of proof. Burden of proof in criminal cases is proof beyond a reasonable doubt. When I was in law school, you had to know the definition for proof beyond a reasonable doubt, forwards and backwards. If you didn't know it, you would feel like such a failure. I had my first jury trial and I was so happy with myself because I was able to say the definition. I put the comma where the comma should go. I put the exclamation point where it should be. And I paused for dramatic effect at the right point. And then after my first jury trial, guess what? There is no definition for proof beyond a reasonable doubt. So the state will not be able to tell you the definition of proof beyond a reasonable doubt. Neither will the defense, because there's no definition for proof beyond a reasonable doubt. So then, as a defense attorney and even as a prosecutor, I had to say, well, how can I explain this to the jury when there's no definition? So I would explain it to them by telling them what it is not. Next door is the historic courthouse. It's the courthouse with the green rooftop. In that building, they handle civil cases, your car accidents, cases involving money, child custody cases. Those are the type of cases they do over there, and along with probate and other things. So they have two burdens of proof over there. One burden of proof is preponderance of the evidence. That means that more likely than not, something happened. If you're ever in a criminal case and you're deliberating and you're in the back and you or somebody else starts saying, well, I think more likely than not this happened, or this probably happened, then you need to remind yourself and remind the jurors, hey, we're not in the right building for that burden of proof. We need to be next door, because that's not the burden of proof for this case. The burden of proof in this case is proof beyond a reasonable doubt. The other burden they have next door, which is their highest burden, is clear and convincing evidence. That's the type of evidence that's used to terminate your parental rights. They think that you're a danger to your child. So they say you no longer will be a parent to this child, and we're going to sever your legal ties and you will not be able to raise your child. How many people think that's a high burden? Yes, no, thank you for raising your card. Practice raising your cards. All right, how many people think that's a high burden to take your child away? Well, guess what? There's a burden that's higher than that, and it's called proof beyond a reasonable doubt. That's the highest burden we have. I want to talk to you about fairness and what fairness means, because people always say, can you be fair in this type of case? Let me give you a hypothetical. I've seen people use this hypothetical before. Let's say, you have jury duty today. So the night before, you make plans. You make plans about the route you're going to take, how you're going to get here, when you're going to leave. You realize that their school has started, so there are school zones. So you've factored in going 20 miles per hour for the school zone. And when you get up, you're an hour early, you're ready to go. And when you come downstairs, your vehicle is on cinder blocks. Somebody has taken your tires, they've taken the radio, the CD player, whatever it is, the 8-track, they've taken all of it. But because you want to do your civic duty, you get your neighbor or you get an Uber or take the Via, and you still come downtown. And then you stand outside in the hallway, you come in, you're sitting here, and somebody tells you, all right, the charge in this case is burglary of a vehicle. Then people would usually leave it there and say, would you really be fair in a case like this? That's really not the question. The question is, will you be able to listen to the evidence? And if you can come to a decision, base your decision upon the evidence that you hear, even though your vehicle was just burglarized. Does everyone understand?
Yes.
So raise your card if you were born yesterday. Raise your card if you slept all last night. The reason why I asked that, oh, you slept all last night. That's good. Other people didn't get a good sleep, right? This is the reason why I asked that question, because unless you were born yesterday and you slept all last night, everybody has some trauma or something bad that has happened in their life. And when you have cases that are murder cases or cases involving children, and this case is not a case involving children, I can tell you that. But when you have murder cases or robbery cases or even drug cases, sometimes jurors will say, oh, this is going to be difficult for me. It's not a matter if it's going to be difficult or not. All cases are difficult, and they should be difficult for everybody. The only question is whether you can be fair. Does everyone understand?
Yes.
So with that being said, the charge in this case is capital murder. Is there anyone here who cannot be fair? And by fair, I mean, is there anyone here who would not be able to sit, listen to the evidence that's presented to you, and base your decision. If you can come to a decision, base that upon the evidence that you hear. Is there anyone here who will not be able to do that? Kind of iffy. All right. So we have 4 and 18. All right. The next thing I want to talk to you about is phases of trials. In Texas, there are 2 phases to every trial. First phase, people love to call that the innocent phase, but it's really not the innocent phase. The first phase is really, did the state prove their case? Yes or no? That's it. That's all it is. Did they prove their case beyond a reasonable doubt? If they did not prove their case beyond a reasonable doubt, then the verdict should be one of not guilty because they didn't prove their case beyond a reasonable doubt. If they did prove their case beyond a reasonable doubt, you have what's called the second phase, and that's the punishment phase. In Texas, anytime someone is charged with a criminal offense, they have to make an election or a selection or decision, however you want to put it, on if they were found guilty, who would they go to for punishment? The law says they have to make that decision before jury selection. Does everyone understand?
Yes.
It's the law. And when people make their selection, they're not making it because they're saying, I'm guilty. They're making it because the law requires them to make it. Does everyone understand?
Yes.
So in this case, Mr. Curtis has decided if a jury were to find him guilty, he would come to the court for punishment. Is there anyone here who's going to hold it against him that he has decided if he were found guilty, he would come to the court for punishment? If that is you, raise your card. Thank you. Now, the next thing I want to talk to you about is languages. I love languages. I think they're beautiful. When I was towards the end of elementary school and middle school, we had to make a choice on what language we wanted to study. I'm originally from Louisiana. You can tell when I have to say words like oil and soil. And thank you. All right, in the back, what's your number? Number 56, where are you from?
New Orleans, born and raised.
Yay, thank you. Okay.
Nation.
So I always thought that I would be retired by the time I'm 22. Here I am, still working at 22. So anyway, I decided that I was going to take French. My best friend said, Stephanie, you should take Spanish with me. I'm like, when am I ever going to need Spanish? Lo and behold, I ended up in law school in Texas, so here I am. But when I was in undergrad and grad school, and even in law school, I was surrounded by students who spoke so many different languages. Usually the people who were from Lebanon, Egypt, they spoke about 8 different languages. Usually the other people from Italy, they usually spoke about 3 to 4 languages. And I love languages. I think they're beautiful. I even had a friend who spoke Navajo. They were trying to teach me. So basically what I've learned is I've learned how to say hurry up in every language. That's what I learned how to say, but I'm working on my Spanish. So is there anyone here, raise your card, if English is not your first language? And once I call your number, please lower your card. 14, 17, 18, 20, 34, 46, 72. All right, juror number 14, what is your first language? Oh, sorry, 53, thank you. Juror number 14, what's your first language? Have you been able to understand everything?
Yes.
Thank you. 17,
Spanish.
have you been able to understand everything? Number 18,
Spanish.
have you been able to understand everything? Number 20,
I'm from Ghana and my language is called Twi.
how do you spell that?
TWI.
All right, how do you say hurry up in your language?
Kaho.
All right, I'm going to remember that. Have you been able to understand everything?
Yes, Your Honor.
All right, thank you so much. 34,
Fine.
have you been able to understand everything?
Yes.
All right, 46, have you been able to understand everything? 53,
Spanish.
have you been able to understand everything? All right. 72,
Gujarat,
and your language?
Gujarati
Where's that from?
from India.
Oh. And how do you spell that?
GUJA.
All right, I do that for the court report. I'm pretending like I know how to spell it and I'm just doing it for the court reporter. But how do you say hurry up?
Jaldi karo or fast.
All right, I'm gonna use the last one. So have you been able to understand everything?
Yes.
All right, thank you. All right, the next thing I'm going to talk to you all about is travel arrangement. Both parties have told me they think this trial will probably be concluded this week. And by this week, I mean Friday. So is there anyone who has any type of travel arrangements? All right. Hold them up now, because once I pass your number will be forever passed. I should say travel arrangements or time constraints. All right, so once I call your number, you can lower your card. 4, 6, 17, 22, 31, 43, 47, 49, 50, 51, 56, 64, I'm sorry, 61, 63, 64, and 68. Did I miss anyone? All right, juror number 4, what's your time constraint?
I leave Thursday morning, going to California.
All right, what are you doing in California?
Oh, I'm sorry, forgive me for not standing. I'm going to a 70th birthday party. We're all, my class of 73, we're all turning 70 years old this year.
Oh,
And Lord said the same, I'll turn 70 next month, so they're having a white party in California. So my daughter gifted me that trip to go hang out with my classmates.
awesome, class of 73. All right, thank you. Number 6,
I need to be in College Station tomorrow at 10 a.m. to move my daughter into her dorm.
and what time?
10 a.m. tomorrow,
And where's your accent from?
Australia.
All right. I meet Australians all over. They're always very nice. As if you would say, you have the wrong impression. All right. And you say that's tomorrow?
Yes, I'll drive there tonight.
Okay. Well, welcome to the SEC. Number 17.
I gotta go to San Abilene tomorrow, and then the week after I gotta go to San Angelo. I work for this company with Go Car Washers. So I'm always traveling full time out of the month.
All right. Thank you. Number 22.
I gotta be in Comstock, Texas on Thursday morning through Sunday, finish up building the house over there for a client,
Okay. Comstock,
Comstock,
Texas.
Yes, ma'am.
When?
Thursday morning.
And what's the reason?
I'm building the house for a client.
All right. Thank you. Number 31.
I take care of my special ed brother. He's not really my brother, but we've been taking care of him since I was about 8 years old.
Well, no, if you say that's your brother, that's your brother.
Yeah, he's really my brother. I call him my brother.
All right. And what are the hours?
Usually until my mom gets home from work, because she's a special ed teacher. He went to school with her, so
All right. So what are the hours?
like about 8 a.m. to like 4:35.
All right. And who's with him today?
My brother, he's off from work today.
All right. Thank you. 43.
I have a school age daughter. I wouldn't be able to get anyone to get her to school tomorrow morning and then Friday morning.
All right. And what is her school hours?
7 to 3.
And when do you take her to school?
I usually take her every day.
I mean, but what time do you leave to have her at school?
Oh, at about 6:57.
All right. So what I can tell you is trial in this case will probably start at 9:15 a.m. But thank you for letting us know. 47.
I
currently her father and I came up jury duty and to attend it. That it's gonna be Friday.
All right, so here's the thing. In order for you to have received notice for jury duty,
I have a residence in both areas. Here in San Antonio and also.
so that's why you're here.
Yes.
All right, thank you. Number 49,
They traveled to New Jersey for my granddaughter's wedding party on the 26th.
all right, so it's for the 26th.
Yes.
She wants you there? Are you bringing the money? Are you bringing money with you? All right, number 50.
I have a flight out on Thursday, Pensacola,
And what are you doing there?
friends 40th birthday.
Okay. All right, thank you. Number 51.
It's not a time constraint. I just would have to take the bus. I thought it was still a travel.
Okay. All right, thank you. Number 56.
I'm working, from 11 to 7 on Wednesday, Thursday 2 to 10, and Friday 2 to 10.
All right, thank you. Number 61. Yes.
Driving out Friday to Tennessee,
And why are you going to Tennessee?
picking up my mother's ashes.
Oh. Well, thank you for letting us know. 63.
Not too sure, but my wife works second shift. So,
I'm sorry, your wife works where?
second shift, so I don't know y'all's time frame. So I have kids at home that are under the age of 12.
And so she works second shift.
Second shift for a Toyota.
All right, so when would the children be alone if she's working second shift?
That's what I'm saying. I don't know how long this process works. So how long for me to get here to over there and
All right, so when does your wife start her shift?
6 o'clock Monday through Friday.
All right, thank you.
Thank you.
64.
More or less.
I have a doctor's appointment on Thursday that took me 3 months to get.
All right, thank you. 68.
Daycare arrangements,
I'm sorry.
for daycare, but I have a grandchildren, the one I take care of. And we only have one transportation. And so it's gonna be kind of hard for me to travel back and forth.
All right, thank you. Anyone else? All right, so let me explain you all about employment. Of course, everyone will take your considerations under advisement, but this is what I tell people about employment. Nobody's indispensable, right? For example, one of my friends, when I was an attorney, they're like, Stephanie, you're working so hard. Do you know what would happen if you were to die tomorrow? And I'm like, oh man, are they shutting down things? Are they holding parades? Are people going to be marching in the streets like, no, she was too kind and beautiful for this world? He said, Stephanie, I'm going to be sad, but they're going to say, okay, who's taking her cases? So I always tell people, sometimes you're not indispensable at your job. When you are indispensable at your job, what that means is if something were to happen to you, if you were to retire from your job, guess what? That job would just become extinct because there's absolutely nobody else who could do that job. And I tell everybody that, and I'm going to tell you all 2 stories, and both are true. My family grew up in a small town called Grand Cane, Louisiana. And I always tell this story because I see jurors, maybe they're frustrated because they're having to wait, they're rushing over, they come downtown, somebody's bright idea decided if you have a bunch of one-ways downtown, it'll make traffic flow quicker, and it doesn't. It just gets people frustrated. You come downtown, you're driving, you see the parking garage where you can park, and then you realize it's a one-way. And then you start thinking to yourself, I know I'm one of those people in San Antonio that's a bad driver, but there's nobody here. If I could just take this one way, get there, nobody will see me. I won't get a ticket. But then, of course, you're law-abiding citizens, so you decide, you know what? I'm going to circle all the way back around. Then I see you all running to the courthouse, and I always tell you all, slow down. I know it says 8 a.m., but they're going to have to check everybody in, so slow down. And then you finally get assigned a courtroom. You're waiting outside in the beautiful hallway where the temperature is just right. Everybody has a seat. And then you're told to come back in the afternoon. So it's an inconvenience. And this is why I say it's an inconvenience. In Grand Cane, Louisiana, my grandmother had an elder son. It was the oldest of all her children. He was super intelligent. So he would go to school, and that was back in the day where every teacher knew every student's name and they knew your entire family. So they would tell my grandmother, they said, Miss Lane, we've taught him all we can teach him. So they would pass him to the next grade. Now, when his brother and sisters started coming to school after him, they didn't appreciate that because the teachers would say, we're expecting a lot out of you because your brother, super intelligent. So he ends up graduating, and he graduates early from high school. There's a conflict that breaks out. You may have heard of it, called the Vietnam War. Now, my grandmother had a 6th grade education, but super intelligent. And her having a 6th grade education was through no fault of her own. It was just the times that we lived in, civil rights, everything going on. And I say she was super intelligent because she would babysit me. And before I started school, I already knew how to tell time, knew my ABCs, and knew how to read, and knew how to answer the phone, and knew how to tell encyclopedia salesperson and insurance salesperson, no, thank you. So my uncle comes to her and he says, because of civil rights and everything that's going on, there's no way I can improve my lot in life here. I want you to sign for me to go to Vietnam. And if you think about it, back in that day, nobody even knew where Vietnam was. They didn't know what it was about. But in moms, I know mothers will say, I love my children all the same, but there's something about the firstborn because you practice on them, right? Being a great parent. So she signs for him to go off, right? And this was back in the day. My grandmother did finally have a television set, but when she first started raising her children, they had a radio. Then they finally got a TV. That TV had 3 stations, ABC, CBS, and NBC. NBC, you can count it as a station, but sometimes it wouldn't work. If there was a breeze, you were going to get static. The rabbit ears with the aluminum foil on it, no amount would help you. And to top it off, you only have those 3 stations. And young people, the way you have 24-hour TV anytime you want to watch, at some point in time, programming would end, and they would either play the national anthem with the flag blowing in the wind, and you just have to wait till the next day for programming to begin again. My grandmother did have a phone, but it wasn't rotary or touch tone, which young people don't know what a rotary or a touch tone is. So let me explain her phone to you. It had no numbers on it. You just pick it up and an operator would answer and you would tell the operator who you wanted. That's why you would have songs like Beechwood 45789 because operator, I would like Beechwood 45789. So when my grandmother sent him off, the only thing she had, of course, his name, because that's her son, and the number he had in the military. And you would write a letter and it would go where it went and you would wait for it to come back. None of this, I'm going to shoot an email, none of this cell phone business where somebody can take a photo, send it to you on your end to say, I made it safely. So she just had to wait for letters to come in the mail. She quickly realized that you do not want people in military dress come knocking on your door because that is not good news. So she just had to sit there and wait, watch TV and see what was happening. And that's it. So I tell people, that's a sacrifice. What you're doing here is an inconvenience. Your country only asks 2 things of you in this world: pay your taxes and serve on a jury once in a blue moon. Raise your card if you have ever served on a jury. And when I say serve on a jury, I mean you got sworn in the box and you were there till verdict. Raise your card. So That is not even half of the people here. And if you raise your card, I'll call out your numbers so that both attorneys will know what those numbers are. So it's 2, 7, 11, 18, 26, 33, 32, 38, 39, 46, 54, 55, 49, 62, 70, and 72. 73?
Yeah.
Not 72. Not 72, but 73. Thank you.
Mhm.
Now, of all of you who raised your cards, how many of you raised your card if those were criminal cases? All right, that's 62, 73, and number 2. Now, of the 3 of you that have your cards raised, how many of those were to verdict? And by verdict, I mean someone was found guilty or not guilty. All right, so that's 62 and number 2. So as you can see, that's still not a tenth of the people here who've actually served on a trial to verdict. So they don't even call you up once every 3 months. They call you up once in a blue moon. So that's all your country is asking for you. So when I see people, they're celebrating July 4th, they're celebrating Veterans Day, they're celebrating Memorial Day. This is how you can celebrate your country and celebrate the troops, by serving on a jury. Does everyone understand?
Yes.
Now, I would always leave that story right there about my uncle. Then Deputy Lord would say, Judge, what happened? So what ended up happening is he ends up making it back from Vietnam. He's since passed, and some of my aunts have since passed, but he did make it back. But the reason why I tell that to you is to let you know that those are sacrifices. This is a small window of your time that your country is asking for. Now, the second story I want to tell you is, I think attorneys who practice civil, they're great, but usually they're not in jury trials. Attorneys who practice on the criminal side are usually in jury trial all the time, or they have to be in court every single day. So my friend had jury duty. We hadn't really spoken to each other that much or seen each other that much in person since law school. So she calls me up and she says, I have jury duty. Let's have lunch. I'm like, great, let's have lunch. So we have lunch and I ask her, how is jury duty coming along? She's like, oh, it's coming along fabulous. Now that I'm a judge, I'm like, how could it have been fabulous? You were not with me. But she says, it's just like when I was in law school, I'm on the back row keeping my head down. I laughed. She wants to know what's funny. I said, I'm just happy because we're going to have lunch every week. So other than not saying anything, the easiest way to be on this jury is if you raise your card and you beg somebody, please let me sit on this jury. I really want to be on it. And I tell that true story to let you know that the state and the defense, they're going to have 1 hour to talk to you. They don't get a chance to go have dinner at your house to learn more about you. This is the only time they will be able to speak to you. So be vocal, answer their questions, and let them get to know a little bit about you. Does anyone need a break before I turn it over to the state? Yes. All right. So ladies and gentlemen, we're going to take a 15-minute break. This is what I want you to do. Look to your left. Look to your right. You're responsible for that juror. So this is what I need you all. Leave your numbers behind. And when one person leaves the courtroom, everyone has to leave the courtroom. And I'm going to need you all lined up outside no later than 2:45. So just line up outside in the order that you're in now. All right, everyone, please rise for the jurors. Excuse me. Can you say that? All right, everyone, please be seated. State, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
May it please the court, counsel, and good afternoon all. I think I got taught a while ago when I started in this, something fair, we got information on you all. My name is Daryl Harris. I am Assistant District Attorney, and for you native Texans, I am what you all, I've been told you all refer to as a dang Yankee. Meaning I got here and I stayed for 24 years. Want to talk with you all briefly and get you all ideas and information. Now, 16 of you have been through this process before. It's a judge laid out that's not even 50%, 25%. I should have calculated it. We're here for jury selection. Now, some of you may think, and I just kind of queried this last night. Anybody ever seen that movie, Runaway Jury? Yeah. This ain't like that. Okay. 2023 film, Gene Hackman is hired as a jury consultant by the gun industry, and his mission is to make sure there is no verdict. Except you got two enterprising people to get themselves onto the jury and they're working against him. Great drama. This ain't like that. Time to Kill. Anybody seen that one? Okay. Same guy. And you're the Louisiana guy. Y'all watch a lot of movies. Criminal Story in Mississippi. Samuel Jackson plays a father who avenges the person that hurt his child. And Matthew McConaughey takes and defends him. And it all turns on this great statement and closing argument. And it literally shocks a member of the jury. And he, oh my God, I didn't think of it that way. That usually don't happen here either. Okay? As the judge laid out, this is jury selection. And really, it's both Mr. Bunk and we're trying to find out information about you to figure out the 12 that are going to be in the final jury. Okay? There are no wrong answers, but we need you to engage with us. Now, we're both, I guarantee you, we're both skilled in running our mouths for a good hour. Okay? But there won't be anything that comes out of it. So, jury selection, voir dire, translated literally speak the truth. Both of us want to know, we want to find out your feelings about certain situations, certain scenarios, the law we think is going to be applicable in this case. Okay? There are no right and wrong answers, but we are asking for you to engage with us. Now, the judge told you all what the kind of case it was, and some thoughts went through heads. Just want to talk with you about homicide. And homicide, the straight up definition means a human being kills another human being. In Texas law, all of that is gathered in a section of the Penal Code, 1901, types of criminal homicide. In general, a person commits homicide if he or she intentionally, knowingly, or recklessly causes the death of another individual. Criminal homicide can be classified into different terms: murder and capital murder. Murder means you commit an offense, again, if you intentionally, knowingly, recklessly do an act that results in the death of an individual. A human being kills another human being. Capital murder means you commit the offense as defined in the homicide statute, and you commit the murder in the course of committing or attempting to commit other crimes, kidnapping, burglary, robbery, aggravated sexual assault, arson, obstruction, retaliation, terroristic threat. It's a straight black letter written out of the code book. Aggravated sexual assault. Under our laws, a person commits that offense if they intentionally or knowingly cause the penetration of the mouth of a person with the sexual organ of the actor without that person's consent. Or if that person causes serious bodily injury or attempts to cause the death of that same victim in that criminal episode, or they use or exhibit a deadly weapon in trying to commit the aggravated sexual assault. All of those are ways that you could commit the offense of capital murder. If you remember those 7 offenses that we talked about, sexual assault, robbery, etc. Robbery. Everybody generally knows what. Anybody ever been the victim of theft? Okay, that one everybody can understand. Theft is in that robbery family. You commit theft if you unlawfully appropriate somebody's property with the intent to deprive the owner of that property. Okay? It's robbery if you do the theft and you cause bodily injury, use physical force, etc. Okay? So if you intend to kill somebody while in the course of committing robbery, that also fits a capital murder definition. Make sense? Anyone? So the judge laid out that we're here by way of a document called an indictment. As she said, a piece of paper, but it lays out the elements that myself, Mr. Spear, Ms. Bogus have to prove at the end of the evidence, come forward and ask the jury for their verdict. All right. And all it means is that on or about a day, October 21st, the defendant, Mr. Curtis, did intentionally cause the death of a person known as Paula Boyd by strangling with a deadly weapon, namely a ligature. A ligature could be anything used to impede the flow of blood or breathing to a person, a rope, a scarf, Garrett, grabbing the shirt around your neck and tightening it up, body limb if it impedes breathing. Any of those things could constitute a ligature, okay? Or an object unknown to the grand jury that in the manner of use or intended use was capable of causing death or serious bodily injury, or by striking that person with a deadly weapon. Under Texas law, hands and fists can be deadly weapons. Doesn't mean shooting or a knife by itself. Hands and fists can be deadly weapons. Or an object unknown to the grand jury that returned this indictment that by their manner of use and intended use were capable of causing death or serious bodily injury, and the defendant was in the course of committing a robbery. That's paragraph A. That is one way, count 1, paragraph A, excuse me, one way of committing the offense of capital murder. Count 1, paragraph B, on or about that same day, same defendant, by strangling with a deadly weapon and by striking with a deadly weapon, and the defendant was in the course of committing aggravated sexual assault. Okay. Beyond capital murder, as we say again, our laws also define murder, a level below capital murder on the punishment scale. We went over types of criminal homicide. A person commits it. If they cause the death, criminal homicide, it can be murder or capital murder. Our laws also allow for what is generally referred to as felony murder. You don't necessarily intend to kill anyone. You only intend to commit a robbery. But in the course of doing that robbery, somebody deceases. All right. Notice the difference. Capital murder says you intend to kill and you're doing one of those other offenses. Felony murder is I only intended to do the other offense. And things went awry. Now, there are various ways that felony murder occurs. One of our felonies is in Texas law, an elderly person is defined as anyone age 65 or older. Committing injury to an elderly person is a third-degree felony crime, generally. Intentionally, knowingly, or recklessly, or with criminal negligence causes to an elderly person. But if you commit what is called serious bodily injury, which is bodily injury that creates a substantial risk of death or that causes death or serious permanent disfigurement or protracted loss or impairment of a function of any bodily organ, bodily member or organ, and we can prove that the person who suffered it was age 65 or older, aggravated assault. Person commits the offense. If you commit assault, that's just slapping on the hand. If it stings or causes pain, under our laws, that's simple misdemeanor assault. If it did so without consent. But if you cause that pain and you use or exhibit a deadly weapon during the commission of that assault, or if there are certain relationships as defined by our family code that also could constitute aggravated assault. Now, I have not really paid attention to 75. How many folks are wedded to another? How many? Just what percentage? I'm going to say roughly looks over half. Okay. So you and your spouse, the person you're married to, anybody disagree about that you're family now? Anyone? Sir, what you know? Row two, right hand, row 2, 6'3". You read me your family to your spouse, right? Yeah. Okay. And how many children do you have?
In total, 8.
Okay. And your children, you're related to them by blood. Legally, we call that consanguinity. Okay. So if something happened, if one of your children hit the other one, that would be an assault within the family or household. Does that make sense? Okay. Did you know that once you jump the broom, my background, that's how we call it. She jumped the broom with your wife, her family, that you're not your blood, also legally became your family. I'm sure you felt that way immediately, right? Sometimes maybe not so much, but legally, if you're married and you're related to somebody by the nature of that marriage, that is family by affinity, is the name under our family code. Okay? So either it's blood, your parents, your cousins, etc., your children and their descendants, or by affinity, your spouse's family. All of that constitutes family relationships under our law. So, under our indictment, there's a count 2, felony murder. And like the count 1, there are 4 different ways of committing felony murder. That on or about this date, the 21st of October, the defendant intentionally knowingly caused penetration of the mouth of Paula Boyd, a person who was older than 65, by the sexual organ without her consent, either by strangling or striking, and thereby caused the death of. That would be paragraph A. Or paragraph B. All of the above did attempt to commit the felony offense of robbery by the acts that we allege, and thereby causing the death, or paragraph C, did commit or attempt to commit the felony offense of injury to an elderly person by the acts that we allege, striking with a deadly weapon, thereby causing the death of. Or paragraph 4. Did intentionally or knowingly commit or attempt to commit the felony offense of aggravated assault against a member of his family by strangling or striking, so any of those 4 ways. And for those who make the jury, we'll discuss that later on at the end of the case. But the point that I want to bring, and the judge mentioned it earlier, it's a whole bunch of words. Got it. I'm with you. A whole bunch of words trying to figure out how to write it. All the indictment does is it's the basis that we are all here today at this point in time. And all the indictment lays out, and this is always the way I've always understood it best, who did what to whom? When did they do it? Where did they do it? How did they do it? That's what we're trying to prove to those who make the jury. Now, where are my Law and Order fans here? Just show of hands. Oh, come on, somebody, go ahead. All right, panel member number 38. You recognize those series of questions? Who did what to whom, when they did it, where they did it, how they did it? What's missing? Come on, help a brother out. Why? More akin to motive. The state does not have to prove why. Anybody care to offer a reason why not? Anyone? Panel member 60, what do you think, sir? How am I doing? Good. So far, you get a little feedback. Anybody, panel member 13, thank you, man.
It doesn't matter.
Okay. Yep. No, well, I tend to agree with you, but also, Fourth Amendment to the United States Constitution, Article 1, Section 10, I believe, of the Texas Constitution. Anyone accused of a crime by the state has a right not to offer evidence against themselves. They have a right to remain silent. And so my point, and so you can all say, inquiring minds want to know. I must know why this happened. You may or may not be able to discern that from the evidence. But there is no obligation to give a why. And so my general question is that if you were to make the jury and we present evidence of the who that did what, to whom, when they did it, where they did it, how they did it, is there anyone that could not return a guilty verdict simply because you did not get evidence of the why? Left-hand side, panel members 1 through 7. Is there anyone that would have to have evidence of the why to return a verdict? Second row of the jury box, panel members 8 through 14. Anyone that requires evidence of why, if you believe the evidence of who, what, when, where, the elements in the indictment. Anyone? And now the reason I'm stressing this, because if you ask me to give evidence of why, you're asking me to do more than the law allows. Does that make sense?
Yes.
Lawyer's bench, panel members 15 through 21. Everybody understand? Anybody disagree? Panel member 18, you're going kind of, okay, can I ask why?
I would just be, I think.
Excuse me.
Better reason.
I'm sorry.
Sorry, if you could just stand over so the court report.
Apologize, John.
I would think it would give me a better idea of where to vote if I knew the why. You know, part of that would be that I know that the law does not require us to hear that, but it would give me a better idea of where to vote
I understand.
if I knew the why.
If there was a why.
And my advocate is always threatening to hit me upside the head if I don't let people finish. Is that your answer?
That's it.
Okay, I understand that, sir. It's human, but you understand my question.
Yes.
If you believed all the elements in the indictment, are you saying you would not be able to return a verdict?
I will be able to return a verdict if I heard all the information.
Okay, thank you, sir. Panel members, behind the lawyer's bench, panel members 22 through 29. Anyone, just with the discussion we had with panel member 18, anyone could not return a verdict. If you believe the evidence of who, what, when, where, how, anyone? I've seen no responses. Panel, row 3, panel members 37 through 43. Same general question. Panel member 40. Okay, I'm sorry, I didn't want to go. 33. How am I doing now? Okay, good. Okay, so you would be able to reach a decision if you made. Okay, I'm sorry, it's second row in the lawyer's fence. I called it third. All right. Panel number 35. Any thoughts, ma'am? No? None at all? Good, bad, indifferent? I'm not putting you to sleep? Okay. The row 3, same question. Panel number 37. What do you think, sir? You couldn't? I'm sorry?
I can't without the wire.
Thank you, sir. Anyone else out of that third row? Anyone think they could not? Fourth row, panel members 44 through 50. Anyone, if you found evidence that was credible and you believed it, of the who, that did what, to whom, when, where, how, anyone could not return a verdict. Panel member, row, and I apologize for getting too close to you, sir. Row 1, 2, 3, 5, panel members 51 through 56. Anyone?
I can't.
You cannot?
I cannot.
Okay, and you understand, by saying you could not, you're asking me to do more than the law requires.
Yes.
Okay. Thank you for your honest answer, sir. That's what we both sides need to know. Panel member, right side of the aisle, up against the wall, right side row 1, panel members 57 through 60. Anyone, if we brought evidence that you believed at a beyond a reasonable doubt standard of the who, what, when, where, how, could everyone reach a verdict? Panel member 59, how you doing today? Alrighty. You're a San Antonio native? Okay. So you wouldn't be dying to know why? You have that cat ate the canary smile.
All right, please remember to stand so the court reporter can hear.
Yes, ma'am, sorry.
That's okay.
And for the record, it's panel member 59. Okay, so you could return a verdict,
Yes, sir.
right? Row 2, panel members 61 to 64. Everyone? And as I asked that, I saw panel member 57 put a card down. So you'd be okay, you would be able to reach a verdict, ma'am?
Yes, because the why is about emotion. Court trials, it's about that.
All right, let me pause your time for a moment. So everyone, the court reporter cannot hear if you all are not standing. The only people who are allowed to sit when they're asking questions are jurors 1 through 21. Everyone else, if you don't stand, the court reporter cannot hear. And if the court reporter didn't take it down, it didn't happen. Make it to-
better about the money.
Okay.
And so, ma'am, just could you stand and repeat your answer to panel member 57?
The why invokes emotion and trials are about facts, and you're not supposed to use your emotions during the court hearing.
Thank you, ma'am. Second row, panel members 61 through 64. Anyone have anything to add to what panel number 57 said? If you had evidence that you found credible and you believed that a standard known as beyond a reasonable doubt would everyone in your rows, 61 through 64, be able to return a verdict?
Yes.
Okay, and to be explicit, if I bring evidence of those elements that you believe that a standard beyond a reasonable doubt, under our laws, I have a right to hope and ask you for your guilty verdict. Could you do that?
Yes.
Okay.
All right, so here's my question. Let me pause.
Yes.
And I paused your time, counsel. You
Thank
can
you.
continue.
Third row, panel members 65 through 68. Same question. If you were to hear evidence that you believe at a beyond a reasonable doubt standard, would you be able to return a verdict of guilty on the indictment, even if you didn't get evidence of why?
Yes.
And panel member, could you rise, please? You are 66. And your answer was 66 was what?
Yes.
Okay. And also rising was panel member 68. Thank you, 66.
Because there has to be a reason why people do things. That's the way I feel. They just don't do it out of just doing it.
Yes, ma'am. I do understand. And for court reporter, were you able to hear what panel member 68 just said?
Let me help you with that. No.
May I judge? Ma'am, if I could ask you to repeat what you just said for the record, I've given her the microphone.
I truly believe that people have a reason to do the things they do. And that's why, it has to be a why you do this. You just don't just do things just to do it. I don't believe that.
Yes, ma'am. And if we could, and I just want to explore this. I understand everything you say, ma'am, and I am not trying to change your mind, but do you understand that the law only requires me to prove the elements in the indictment? They may or they may not get to the why. And so are you telling me you're asking me to do more than the law requires to get your guilty verdict?
I'm not asking you, I'm just telling you how I feel.
Yes. And I do not mean to interrupt you, ma'am, I apologize. Okay, but if you could not do it and you have a belief that I proved the elements, you understand you're asking me to do more than what the law requires.
Yeah, I understand.
All right. Thank you, ma'am. Next row, panel members 69 through 72. Same question. If you heard evidence and I proved the elements in the counts that ultimately prove who did what, when, where, how, is there anyone that could not return a guilty verdict in deliberation if you don't hear evidence of motive why? And for the record, your panel members, what's your number, sir?
71. In the beginning, yes, I thought that if you didn't have the why, it wouldn't, you wouldn't have a conclusion of what they did it for. But once I seen the who, what, whom, when, where, and how, there wouldn't be no reason for what. So I would vote, I would be able to vote without the why.
Thank you, panel member 71. Last row, 73 through 75. Same question. Is there anyone that would ask me to do more than our laws require? And so now, our standard in a criminal court, the judge has outlined it as what's called provable of beyond a reasonable doubt. Under our laws, and the judge has laid it out, everyone accused is presumed to be innocent until the state does their job, proving the elements, to prove them. No, it's not beyond the shadow, beyond all possible. But jurors, it is the highest burden in our justice system, criminal, civil, etc. But it is not an impossible burden. It is a burden that is met in every traffic court, in every misdemeanor court, in every district court, in every county, in every state, across our union every day. Citizens such as yourselves who get gathered with a group of 60 or so of their new best friends, listen to evidence, go and deliberate, and they reach a decision. So it's possible. I know it can be emotional at times. And the way the process starts, once we have a jury, we start with that presumption of innocence, and then we introduce evidence over the course of the trial, evidence that indicates who did what, to whom, when, where, and how they do it. And it is our intent, it is our mission to walk the jury to what we believe is at the end state of the evidence. Does that make sense?
Yes.
Also want to try and define some terms that come up. The term coercion, when you think about the assault of offenses, a threat, however communicated, I'm sorry. And we just have to produce evidence of it. Does the chart indicate possible intimidating or coercive behavior?
Yes.
Yes.
I guess if you're the big dog, probably not though, right?
I'll read it you all on.
Or in a more human occurrence. Deadly weapons. Deadly weapons mean anything that in their manner of use or intended use is capable of causing death or serious bodily injury. What's the most obvious deadly weapon? Panel member 20, sir, what do you think?
Gun?
Guns? Yes, sir. And I apologize. Go ahead, rise, please.
Gun?
Guns. Anyone want to join panel member 20? What's the other obvious deadly weapons?
Knives.
That was panel member 52, said little knives. Okay. What about hands and fists? Is that?
Absolutely.
Please rise, sir. Panel member 18.
Fist, hands, yes, that could be a deadly weapon as well.
Panel member 52.
Metal pipes.
Smell. Pretty much anything. Depends on how it's used. It's the manner of use or intended use. So, can we all agree that hands, fists, body parts, depending on how they're used, can be deadly weapons?
Yeah.
Is there anyone that disagrees? Looking at row 1 of the jury box, panel members 1 through 7. See no disagreement. Panel members 8 through 14. Scanning the lawyer's bench to the left. Okay. Now, I want to talk about witnesses, testimony. Panel member 58, sir, how you doing?
Good.
Okay. What type of, if you know the charge, the indictment is a murder trial, violent crime, what type of witnesses, fact witnesses might you expect to offer evidence in a violent trial? I could ask you to stand on the card, sir.
I would assume someone that was there.
Okay. And well, what would you think if you had the gentleman in the picture in front of you? He's got tattoos, ear piercings that would have got to be painful places on his face. Versus, what's the picture on the right, sir?
That's like a nun.
Okay, if you're looking at potential witnesses, just thinking abstractly, which would be the type of witnesses you think you would possibly have evidence in a murder crime?
Based off of them,
Yes, sir.
I would assume.
Okay. And I've intentionally drawn these two extremes because witnesses come in, nobody chooses necessarily to be a witness. Would you agree with that?
Yeah.
And oftentimes, people who are witnesses in crimes, they don't necessarily want to be there. Maybe we've had to subpoena them, or maybe their conscience just says, I've got to tell what I know. They may have their own impairment. Does that make sense?
Yeah.
Okay. And if that happens, you're going to hear about those impairments. Maybe they've had issues themselves. Does it mean that they're not telling the truth just because of what they had or did when they came in, when they saw the thing that brings them here?
No.
Okay. So the question is, depending on whatever you may find out about a witness, could you listen to that witness's testimony and judge its credibility based on what they say, not on who they are?
Yeah.
Thank you, sir. That's where I'm going. I want to talk a little bit about evidence. Evidence generally comes in two types. There's direct evidence. Right now, if you all get called to testify about how Harris stood up here and did it, you all are eyewitnesses. I'm either boring the heck out of you or annoying. I hope I'm not annoying the heck out of you. But you all have direct evidence. You're hearing it, you're participating in it. Nowadays, direct evidence, we have the benefit, there's more cameras now than there were, but there's cameras everywhere, right?
Yeah.
You can see it. It's tangible. You understand it. There's also what we call circumstantial evidence. Circumstantial and direct evidence, a lot of times, they work together. You may know something from previous testimony, so that when you see some direct evidence, you now have a context to understand that direct evidence better. Does that make sense?
Yes.
Yes.
Is that the type of analysis that we all do in our daily lives? Okay, show of hands again. How many folks are married? So, okay, my wife and I, it's been 42 years. And she knows me too doggone well, I'll say. But it's a great example of she might see me do an objective thing, but it will make her mad as a wet hen. Why? Because she's got 42 years of me. She's got 42 years of knowing she told me, don't do that. And I do it anyway, and she gets mad. It's the circumstances, the facts of what happened. Does that make sense? Is that the type of analysis quite often can cause you to understand something? I'm a lapsed back row Baptist, I'll tell you that right now. But as I grew up, from where I was from, there was a saying that when the preacher would say, when you know that you know that you know. Does that make any sense to anybody that's not Baptist? That's how the types of evidence interact. They play off each other. Sometimes the whole is more than the separate parts. The types of evidence you see, nobody can exhaust it. Every fact pattern, every alleged crime is different. But only you, the jury that make it, you are the ones that get to assess what weight to give evidence. You're the one that decide if it's credible or not. And that's how you get to understanding if the elements have been met. Persuasive. Can be anything, facts, data. It can be valid, it can be reliable. One of the other things that also has come up, and I've been talking before juries since 2005, but it's only since COVID in 22 that this particular thing became an issue. There was a time when we could talk about scientific evidence. And it was generally accepted, but with everything that came with COVID and vaccines, et cetera, and it's not unusual to find that some people have questions about scientific evidence. Is there anyone in generally that questions maybe what you used to know? Anyone? Row 1, panel members 1 through 7. Row 2, panel members 8 through 14. Lawyer's bench, anyone? Next row behind the lawyer's bench, panel members 22 through 29. Anyone question? Second row, 30 through 36. Third row, panel members 37 through 43. 37, 38, 39. Sir, what do you think? If I could ask you. What do you think about scientific evidence, sir?
I think scientific evidence today versus years ago is much better. I would tend to believe science.
Okay. And I'm not asking you to not question it. Okay, but you have no problem with the concept of scientific evidence. Thank you, sir.
I do have a question.
And yes, sir, if I could ask you to raise your number, please. Okay, 39. What's your question, sir?
So you had the circumstantial. Within there, underneath was motive.
Yes, sir.
And we had talked earlier that motive is not one of the elements, but I'm a little bit confused on that.
The meaning of it, motive is not a required element. But the reality is quite often the way all the evidence works together, you can gain insights into it. All I'm saying is I don't have to give a specific motive. I don't label it. Does that make sense to you?
So it could be used in process, but it can't be used as your gift itself.
Thank you, sir. Do you mind if I steal that? All right, I'll engage Mr. Bump to represent me in the negotiation. Thank you, sir. And scientific evidence in our justice system, the earliest part of it was the ability to go to an inanimate object. I'm just touching council table here. And what have I left on council table? Panel, sir, I can't recall your number. Panel member 2, 3, 4, 5. Panel member 26. What did I just leave on council table when I laid my hand on it?
Skin.
Fingerprints. Thank you.
Part of your lunch. I don't know.
That's another one of the reasons my wife gets mad at me. Yes, sir. And we know that the earliest development in that scientific empirical evidence was the ability to gather fingerprints and analyze them and store them and associate them with an unknown individual. Now we know, as all the things that panel member, what was your number again, sir? 26. Everything he laid out, sweat, whatever else I may have carried from another area, all of that could be there. So it started with fingerprints. Nowadays, I've used one of these commercial services for DNA, and I've been able to track my father's bloodline and lineage to a particular village on the western horn of Africa. My father's descendants of the Akan tribe. You know, jumped on. Is anybody here questioning, anybody here ever use any of these services for your own family lineage? Row one, panel members 1 through 7. Anybody? Could you raise it? Just raise your numbers if you've used it before yourself. I just want to count the numbers. I see 7. Second row, anyone? 13, anyone in the lawyer's book? 21 has raised their card. 22 through 29, anyone? 29 has used these type of services. 30 through 36, anyone? 32 has used those type of services. 37 through 43. 37 has used those services. 43 has used those services. 44 has been holding his card up. 45, 47. In the last row, 51 to 56, 52, 54. Going to the right-hand side, row 1, 57 to 60. Nobody's used those services. Row 2, 61 to 64. 64 has used those type of services. 65 through 68. 66 has used those services. 69 to 72. Anyone? 69 has. And 73 to 75. 75 has. All 3 have. My only point is they've become somewhat accepted in our society nowadays. As you've demonstrated, we use them in our daily lives to find out things that we're curious about, etc. So you may or you may not hear evidence of biological or DNA testing. Is there anyone, for those that didn't raise their hands, is there anyone who questions the science that you would not believe that evidence solely because it comes out of a test tube? Anyone that would not is what I am asking. Looking through row 1 through 7, panel member number 2. Could I ask you to rise, sir?
Certainly.
Okay, could I ask your thoughts on it?
Well, my thoughts are I'm skeptical of it. In the past few years, we've heard a lot of things that were potentially wrong. People have been wrongly imprisoned, and that's scary. So I'm very skeptical.
Thank you, sir. Second row, 8 through 14. Anyone? Anyone agrees with panel member number 2's assessment? Lawyers bench, panel members 15 through 21. Panel member 18.
I agree with,
Can I ask you to stand, sir?
yes, sir.
Okay.
I will, in layman's term, I think it's a bunch of hooey when it comes to this. Like you said, I've heard stories about how those tests have been wrong at times. And so I really don't believe in it completely, 100%, not yet. Maybe later in a few years, but right now, no.
Thank you, sir. Yeah. Row 2, panel members 30 through 36. Anyone that agree with panel members 2 and 18? What up? Second row. All right. Correction. That was the first row. My bad. I apologize. Second row. Panel members 37 through 43. Good Lord, I'm wrong. 30 through 36. I apologize. So panel member 30 has raised his card. Panel member 32 has raised the card.
I believe in the science behind all DNA testing and everything. I just worry about the processes that go into it and the collecting and potentially being tainted evidence. But I do believe in the science.
Thank you, sir. Panel member 32.
Yes, I also believe in the science, but I also had an experience with 23andMe where I submitted 2 different samples and they both came back different. So that causes me to question to the accuracy of the actual test that was conducted. What's the controls to make sure that that sample is indeed the individual sample that was there and it hasn't been tainted. So yeah, I have some skepticism about that.
Thank you, sir. Third row, panel members 37 to 43. Anyone? Panel members 44 through 50. Panel members 51 through 56. Right side of the room, panel members 57 through 60. Panel members 61 through 64. Panel members 65 through 68. And for the record, panel member 65, I see you didn't rise, but you're shaking your head left to right at me. Does that indicate you don't agree with the science?
No, I agree. Look at the fingerprints, it matches.
Could I-
The fingerprints matches, it matches.
Were you able to hear? I'm sorry, could
Here,
you speak
let me-
up?
Here.
She said if the fingerprint matches, it matches. Right?
Yes, if the fingerprint matches, it matches.
All right, and were you shaking your head because I'm annoying you or? Thank you, ma'am. Panel members 69 through 72.
I'm a little skeptical about the science of it because of tampering, misplace of evidence. Yeah, but I believe in the science, but I'm a little skeptical about how it get mixed up. If somebody sends DNA to the mail and they send you back saying I'm not their child, and in reality I'm their child, I have a little problem with the evidence being.
And you are panel member 71, correct, sir? I just said it for the records. Right. And last row, panel member 73 to 75. So again, evidence in general. Let's get through this, drive on. Bottom line, we're gonna bring evidence of the who that did what, to whom, when, where, how. Whatever we have, we will bring it to you. It is up to the jury to assess how effective that is. And that may answer some of the questions you heard expressed here. Now, this question I want to go very, very specific because I'm trying to, again, get down to your feelings in general. I'm going to go to every one of you and I'm going to ask you, just in general, your general feelings. Number one, since I'm very skeptical about police and the legal system these days, I don't think you can trust any of it. Or number two, our justice system works so poorly, I think most of the people that get convicted are actually innocent. Three, I know there are advantages or disadvantages in life. I still believe people are basically decent and want the same thing. You get what you work for. Number four, if I believe if you did the crime, you should do the time. Now, I'm not trying to pigeonhole you, but I'm doing this for my own purposes. So I'm just going to go through each one of you by row, call your number, and I just want you to respond with a number one, a two, a three, or a four. Okay? Panel member number one, what is your answer to that situation?
One's over there.
Geez, number one, thank you, sir. Appreciate it,
All right,
Charles.
if I could just pause you for a moment, could I have parties?
I think maybe a more effective way to do it. I'm gonna ask everybody that agrees with number one, just raise your numbers. Okay? And we'll call them out, and then we'll ask everybody that's a 2, everybody that's a 3, everyone that's a 4. Does that make sense?
Yes, sir.
So if your honest, heartfelt feeling in general about our criminal justice system, all those who are number ones, just raise your card. Looking at row 1, panel members 1 through 7, no cards. Panel member 2, the numbers I see for number ones are 17, 18. Who else? Anybody else? No one else on the left-hand side. Looking at the right-hand side of the room. You are number 1, raise your card. Are you a number 1, sir? Panel member 67, panel member 71. Okay? All of those who are number 2, raise your card if that's where your feelings are. Panel member number 2s are 16, 26, 28, 20. Looking, scanning the room, don't see any other number 2s. Coming to the right-hand side of the room, panel member 65 is a number 2. All of those who agree with sentiment number 3. That's 3 is number 2, number 3, number 5, number 6, number 7, 9, 10, 11, 12, 21, 22, 27, 30, 31, 32, 33, 36, 38, 40, 43, 44, 45, 46, 47, 25, 48, 51, 52, 54, 59, 50.
56.
All right, solid. Thank you, sir. 56, 57, 58, 61, 64, 65, 66, ma'am, 68, 72, and 75. Finally, those who your feeling is actually number 4. Number 1, number 4, number 7, number 8, number 9, number 13, number 14, number 15, 23, 24, 29, 39, 40, 41, 34, 35, 42, 53, 55, 49, 59, 62, 63, 65, 69, 70, 71, 72, 73, 74. And I said 71, right? All right. Yes. Thank you. Ultimately, the evidence comes in, whoever makes the jury, they are ultimately the sole decider about, be it the tattooed guy with the pins in his face or the nun's testimony. They decide the surety of how physical evidence got collected. The jurors are the ones who decide credibility, effectiveness of the evidence. And that is both state's evidence. I don't know if there will be a defense case in chief, but if they do put on a case, there is no presumption that the defense case is truthful. You hold them to the same standard that you hold the state's evidence. The most important asset you have is your life experience, your reason, your common sense. I used to call mother's wit. Now, I don't know if there will be a defense case in chief, but if there is one, I want you to talk that there are rights that in my job, I am sworn to try and protect. I guarantee you, Mr. Bump and Ms. Lindsay, they will do a good job of smacking me down if they think I'm violating. All of these things are here, the right to a fair trial by jury. That's what we're going through right now. We've already talked about the presumption of innocence. They don't have, nothing has to be stated. All of that you've heard about. The right to cross-examine state witnesses. from looking at the jury card, I think I'm not necessarily on, I think that went too fast.
2 minutes, 38 seconds.
Thank you, Judge. I'm of the Desert Storm generation and age. That's when I served. I've always liked this statement during Schwartz call. Ultimately, you can have your doubts. I ask you to follow your conscience if you make that jury. So, some general questions. I want to go to number 2. Anyone here have family or close friends that have been affected by a violent crime? Just show of hands. Anyone? Panel members 6. Panel members 4, 3, 13, 16, 17, 10, 18, 19, 22, 32, 39, 47, 48, 42, 35, 28, 36, 29, 56, 64, 61, 66, 67, 71, 69. Is there anything about that experience that would prevent you from being a fair juror if you were selected for this trial? I think I got 16 already. Of those who raise your hand, is there anything that would prevent you from being, if you made this jury, from being a fair juror? And number 3, anyone here have family or close friends that have been to jail or prison for committing a crime? Do you feel your relative or friend was treated unfairly by the system? Show of hands if you have it. Panel member 28, panel member 48, panel member 66,
30.
Panel member 30, panel member 39. Anything I failed to ask you that might interfere with your ability to be impartial? Show of hands. Panel member 4, can I ask what that is, ma'am, please?
Okay, so
Who's
my-
Ross?
I'm sorry. Give me not saying. So I was in a situation where my deceased husband attempted my life first. He shot me in the face, and then he killed himself like 10 days later. He's on the run. So all this murder and all this kind of stuff is, just bringing up all this old stuff for me. It's just not. And my brother also murdered a lady, wrapped her in a rug, threw her in the street, was on the run for a little bit. He did his time. Like I said, he did the crime, he had to do time. So it's just a lot of, bad things that happen, as far as my, relatives and friends and stuff. So.
Thank you for sharing.
All right, time.
Yeah, ladies and gentlemen, I believe the state's time is up. I thank you for your attention, and we look forward to working with 12 of you.
All right, does anyone? Yes.
No.
Does anyone need a break? All right, ladies and gentlemen, I'm gonna have you all come back at 4:15. 4:15. Yes. Oh, yes.
Well, how many times a month? Oh, but I was thinking food like a breathe. No, we call it to get home.
Yeah. He's like.
That's my one.
I got it. Yeah, I got it. Oh, yeah. These are here for you. I wrote them in there. That's best I say.
No.
Okay.
Well, I have to start on. They'll want that.
Oh, no, I'm okay.
Then you may proceed.
Thank you. Good afternoon, everyone. I'm Charles. This is Lindsay. This is RC. First, what can I tell you? I can tell you that we know from what Daryl put up there, this case allegedly happened, 10 years ago. So RC has been waiting a very long time. So long that Lindsay was at the DA's office back then when I first met RC. So we thank you for coming out. I'll tell you this, I love what I do. I love my job. And one of the things I love about it is I get to work with my friends, right? I get to work with the judge who I've known for a long time, since your 21st birthday. I get to work with Daryl, who used to work for me back in the 2000s. Stephen, I've known forever. The reason I tell you this is these guys are my friends. You probably saw earlier, Daryl and I will talk. We're friends. I talked to him over the weekend. Now, we disagree 100,000% about this case. We're never going to agree about this. But I'm not ever going to not be their friend. I'm not going to not be her friend if she rules against me. They're my friends. Lindsay's my friend. I tell you this because I don't want you to think, well, I see Charles and Daryl talking, so the fix must be in. Poor RC, he's stuck with that guy who's friends with the state. That's not the case. I always want to tell people that because I can't help but talk to my friends. I mean, it's what I do. I talk for a living. The judge says some people come to court every day. I'm that guy. Lindsay and I come to court every morning. We walk in the courthouse at 8:30, and every day we leave around 1:30 to 2:30. And this is what we do. We help people like RC. And when you get to a case like this, there aren't a lot of them. It's a capital murder case. So what does that mean? Well, capital murder means what Daryl put up on the indictment. If you were to believe beyond all reasonable doubt that he did the things they say he did, you could find him guilty of capital murder and he would get life without parole automatically. That means there's not like what's going to happen. That's what's going to happen. Automatic. So it's a big deal. It's a very big deal. It's a huge deal for this gentleman right here. And the only way this works is if 12 people sit up here with us and they can be fair. That's, Daryl says the most important thing is your common sense. That's important. But the most important thing is that you can be fair. You can give this man the fair trial he deserves. Just because they say it's so does not make it so. I'm skeptical about a lot of things they do. Somebody said they're skeptical about DNA. I am too. Here's why. Daryl rubbed his paw all over my desk. If I come up here and I sit and I lean on it like this, I've got his DNA on my arm, right?
Yes.
100%. So then we have so now let's just say Daryl says Charles assaulted me and I had to grab his arm to defend myself or whatever, and we're in a trial, and the trial is whether or not Daryl grabbed Charles's arm. Well, the state's going to say, hey, he's got Daryl's DNA all over his arm. Of course he grabbed his arm. The DNA says so. I'm skeptical because that's not what happened. I'm skeptical about a lot of things. I'm skeptical about the statement that says, whatever we have, we will bring it to you. We'll see. I just want RC, Lindsay, and myself to have a fair shake. It's real easy to sit here as a citizen and hear what they've said he did and think, well, hell, he's here. He must have done it. And if they bring on some evidence that makes us think, well, he probably did. Well, if our choice is let this guy go or convict him, we probably should convict him because they told us to. I'm skeptical of that. That scares me a lot. Because I know people want to think, well, hell, you know, I'm telling here, I'll let the cat out of the bag. They can't tell you what the case is about other than the indictment, but I will tell you it involves a dead person. So there's pictures of dead people. They're not pretty pictures, right? You're going to see them in black. They're going to tell you things. You heard the words aggravated sexual assault. You hear that and you go, ugh. So your gut says, well, hell, he you know, if Daryl and Stephen, who are, you know, about the best they have up here, if these guys are here saying he did it, well, he must have done it. I don't care what Charles and Lindsay say or do. If they say it's so, it's so. Well, that's not the case. 100% not the case. There are people that are indicted and found not guilty all the time. There was a murder found not guilty in this county a week ago, and another one the week before that, and another one the week before that. This same office told 12 people, this guy's a murderer, and the jury said the hell he is. No, he's not. You did not prove your case beyond a reasonable doubt. Because that's the proof. Now, Daryl says to you, it doesn't mean beyond a shadow of a doubt. It might, if that's what it means to you, then that's what it means. No, I agree with Daryl. It doesn't mean beyond all doubt. I can't prove anything to any of you beyond all doubt unless you saw it happen, right? If I walk up and I grab this girl's glasses and I break them in half, and the trial is, did Charles break this girl's glasses? Daryl's the prosecutor. He could call all of you as witnesses because you saw it happen. And if you're a witness, you can't be a juror. So if you just take the next step in logic, it's impossible for them to prove anything beyond all doubt because you didn't see it happen. So then they're stuck with beyond a reasonable doubt. The judge is right. We all knew the definition. I didn't pause as well as she did for effect, but we all knew it. Now it's pretty much, if you're not sure, he's not guilty. That's pretty much what we've come to. But how do you be sure? How can you be sure? Well, with that, you can use your common sense. You can listen to the evidence. Why didn't this person say that? Or why did this other person say this? Use your common sense. The juror told you, you are the sole judges of the credibility of the witnesses. You and only you will get to decide when the witness finishes, how much, if any, do you believe? I believe everything that person said. I believe some of what person that said, or I believe none of what that person said. That's up to you. The judge won't give you a thumbs up or a thumbs down like a Facebook review or Yelp or whatever you kids use. It's up to you to think, what do I believe that person said, if anything? Now, how do you do that? You just use your common sense like you do at work, like you do at home. It's not tough. What makes it tough is the guilt they want to place on you. That's what makes it tough. Because they're going to stand up here and say, send a message to the community that if you do this, you should be found guilty. And I say what the jurors in the last 3 weeks have said, send this message to the DA. If you want me to believe something, prove it to me. Beyond all doubt, beyond any reasonable doubt. Look at the evidence. Look at what people say. Look at what they don't say. Think to yourself, why did he say that? Think about, well, Daryl, you said whatever we have, we will bring it to you. If I point out things that they have that they didn't bring to you, ask yourself, I wonder why. I wonder why. Be a skeptic. Just like you said, some of you were. Be a skeptic. Ask yourself, why not? And then it's kind of like you take a test, like my son just took the CPA test. And I asked him, I said, well, do you just write an answer or do you have to show your work? Remember, because there were some tests you have to show your work. He said, no, you don't. You just put the answer, whatever your answer is, you put it down. I say this is like that kind of test. You can answer the questions at the end, but they have to show your work. They have to show you why they want you to do what they want you to do. Why do they want you to give this guy life without parole? Why? And so,
Yes, all right.
now, they used a word like, I'm curious as to why they put up the word coercion and what coercion meant. Because in the indictment, there's no coerce. There's a lot too. There's 3 pages of this thing. But the word coercion, not in here. The word coerce, not in here. So I'm already skeptical about, hey, what are they trying to pull? And who knows how a case gets to, has anybody been on a grand jury? Anybody? Okay. So what happens is the police say something happened. Let's say the police make a report that I broke our glasses. That report gets filed to the DA's office. The DA's office then decides, after looking at the reports, what should we charge this person with, right? And then they draft their indictment. This is the product of the state, of the DA's office. They say, hey, here's what we think we can prove. Let's indict him for that. In this case, it's that, or maybe that, or maybe that, or, well, if they don't believe that, maybe they'll believe this, and or maybe that, or maybe that. There's a lot. I'm skeptical. If it was as easy as they want you to believe it was, they'd indict him for capital murder, period. That's the end of the story. That'd be all we have. They choose to bring these charges. Logical inferences. That's what Daryl said. Logical inferences. The problem, and I know what he's trying to say, and I know what he wants you to believe. I know what these inferences are he wants you to make. The problem is, with logical inferences, you have to take basically a leap of faith, right? An inference means you don't know something. You think you know for whatever reason, but you don't know. So he wants you to, he says, you're going to make logical inferences. And I would argue that goes both ways. You can logically infer that this is what happened because Daryl says it's what happened, because this is, the detective says he thinks that's what happened. But you can also, using your common sense, look at it and logically disagree. You don't have to take this leap of faith that they want you to take. You just have to be fair. You have to know that they have to prove every one of these elements. Who, how, when, why, who, how, when, where, and what. They don't have to prove half of them. They don't have to prove 90, they got to prove every single element. And every single element has to be proven beyond a reasonable doubt. I can tell you 1,000,000 times for sure, beyond a reasonable doubt is not equal to a logical inference. Apples and oranges, as my kids say. Not the same thing. but you can be fair. My fear always is in a case like this, jurors are scared to be fair. They're scared to go home and tell their family, you know, I was on that capital murder trial and I found that guy not guilty. Because it might leave a bad taste in your mouth. It might not sit well with you. But if in your heart you believe that's the correct verdict, I need you to be fair to him and tell them, you know what, I'm not jumping off this cliff with you. I'm just not. I'm not making that logical inference. Period. I know all of you have had experiences in your life, some good, some bad. Some ladies, like this lady has informed of us, terrible things have happened to her. And she says, hey, Charles, I can't be fair. And I respect that so much. I'm sorry for what you went through. But she did the right thing. She told us up front, Charles, Daryl, I can't be fair. Because you got to think to yourself, if it was changed and you were sitting over here with us and somebody else was over here, would you be a fair juror to that type of case? Knowing what this is, knowing that there's an element allegedly of aggravated sexual assault, knowing there's an element of a dead person, all of those things, in addition to the two people that said, I just cannot be fair, is there anybody out there who's had time to think about it and, listen to what Daryl said, maybe listen to something I said and think, you know what, Charles, I need to tell you right now, I can't be fair. Not that I don't want to do it. I'll be happy to do it, but I can't do it fairly. Anybody feel that way? 16, 18, 17, 60. And I appreciate that. Because I don't want to put you in a bad spot. 72 and 65. I'll tell you a story. 22. I was a DA in 1997 in a county called Fort Bend County outside of Houston. My partner was a guy named Gil Epstein. Gil and I were hired on the same day at the DA's office. We were court partners like Daryl and Steve are. We spent every day together. One night, Gil was murdered. They found his DA badge. We used to get these cool badges. I don't know if they do anymore. They were neat. I had mine. Gil had his. Unfortunately, when the guys that robbed Gil that night saw his badge, they thought it was a cop and they killed him. So Harris County, they're going to try capital murder. One of the jurors didn't say anything during voir dire. Gil Epstein, shockingly, was a man of Jewish belief. Right? I say shockingly because his name was Gil Epstein. He and I always talk about that. We had a juror that, for whatever reason, didn't say anything. I don't like Jewish people. And yet, when they got to voir dire, to deliberation, she sat in the window of the jury room and said, I'm not going to do anything to help a Jew. And that trial that took 5.5, 6 weeks, they had to do the whole trial again. There's a mistrial because you got a juror who won't participate. You got to do the whole thing again because one juror didn't speak up and say, you know what, I just can't be fair. So I talk about fairness all the time because I think about that day all the time. I think about guilt all the time. I was a DA then. I get it. But the same thing applies. If you can't be fair, it's fine. If it was a trial about somebody who was hit by a drunken driver, I think there's jurors out there who says, you know what, I couldn't be fair in that case. If it was a trial about somebody's car getting broken into, maybe some of us say I couldn't be fair in that case. Now, those aren't the facts here. You kind of have an idea what Daryl wants you to, what the leap he wants you to take. But I just want to make sure that everyone has a chance to say, Charles, you know what, thank you for letting me talk. I can't be fair. Because here's what's going to happen. When we finish, and I'm going to talk, I'm not going to use my whole hour. Y'all can all, yay, Charles. I'm with you, brother. I'm so with you. If I look tired, it's because I am. But what happens is when we finish, they go to their little room, we go to our little room, and we have our list. and we mark off 10 people for any reason we want. I can say number 7, who's 7? 7, well, I can spell even better. Number 6, I did not go to A&M, nor do I like anybody whose child is going to A&M. I don't want her on my jury, cross her off. I went to Baylor, so we hate Aggie. No, I'm just kidding. But any reason at all, we cross off 10 people. They get to do the same. The jurors that we get are the people that are left on the list. So it's not picking a jury, it's picking who you don't want, and then technically you get who's left. So how do you make sure you're left? Don't say a word. Be real quiet, because Lindsay and I'll be saying, what about number 2? Man, number 2, he talked, okay, I like him. About number 3, she was quiet. I don't know anything good or bad about number 3, so you're going to get on, right? So, I mean, I encourage you in the 5 or 10 minutes I'm going to keep talking, talk to me. Ask me a question. If something bothers you, tell me. Because I just want a fair shake. I love my job. I love it because I get to talk to people every day. I love it because I watch jurors set aside their biases and their beliefs, and they're fair and they do the right thing. That is such a beautiful thing. So let's talk about people who, let's say one of the elements that Gerald alleged was aggravated sexual assault. Anybody have any personal or familiar or family individuals who've been affected by that type of crime, who thinks, you know what, Charles, if that's involved, I'm not your person? Anybody feel that way? 4, 16, 18, 28, 30, 32, 35, 41, 44, 45, 47, 48, 52, 61, 68, 69. And I appreciate that, because I don't want to put you in a situation that makes you, I don't want you to be that juror sitting in the window. As a defense lawyer, that's our biggest fear, is what questions didn't I ask? And have the juror say, you know what, if you'd have asked that, I'd have told you if you'd have asked me that I shouldn't have been your juror, because I was going to convict him the minute I saw it. Speaking of seeing him, anybody, I know you all said you don't know any of us. Has anybody heard anything about this case? Anybody remember reading the name R.C. Curtis or anything about that? Oh, okay. 31. 48. 23, 26. Okay. 54. Yes, ma'am. 54. Now, I'm not going to ask you what you read or saw.
I don't recognize his name, but her name.
Her name. Okay. Paula Boyd. Okay. Without telling us what you read or saw, can you?
All right, can I have you all approach?
Yes. So obviously there's a possibility that some of you may know something and maybe could or could not be fair. We'll talk about that individually. I'm not here to embarrass anybody or put anybody in a spot where they say, you know, I wanted to answer, but I was so embarrassed by what I was going to say here. Sometimes people feel like, you know, Charles, I want to answer your question, but I don't want to do it in front of my 74 new best friends. I'd like to just tell you and the judge and Daryl. So is there anybody out there who feels like, you know what, I got something to say, but I don't want to say it in front of everyone? Anybody? 20? Okay. I appreciate that. Second question that I need to ask always, there are individuals for personal or religious beliefs that just flat out will not or cannot sit in judgment of another person. Anybody? You say, you know what? Because of my personal or my religious beliefs, I cannot sit in judgment of another person. 3, 31, 35, 30, 58 and 60. Okay. Questions from somebody asked me a question. How about let's turn it around. Y'all, anybody got a question? Yes, sir. Thank you.
Okay,
Help me out here.
my question is, how come your defense attorney, you know, the DA and like the DA also knows the judge? Is there any like conflict of interest? I mean, how can you convince me that, you know, like the defendant is gonna get like a, you know, like a fair?
Okay, that's a very good question. And I'll say this with a little braggadocious, is there a word, braggadociousness? I promise you, you will know in about the first 5 minutes that there's no conflict, that I'm 100% Team Curtis. I will object probably more than you want me to. And that's okay. My job is to make sure that whatever happens, he gets a fair trial. You have to make sure you're fair to him. I have to make sure as his lawyer that they're fair to him. That they don't ask questions they're not supposed to ask. That witnesses don't say things they're not supposed to say. And I'm very confident that whoever's on the jury won't think that there's a conflict because I'm friends with them. Does that I guess I'd say trust, I guess I'd say watch and you'll see. If you get the chance, I don't think you'll confuse whose side I'm on. I feel very, very strongly about RC in our case. I feel very strongly nobody's going to take this leap of faith they want you to take, frankly. Other questions? 39. Yes, sir. I'm a man of science, he says. Like Nacho Libre.
Don't know if this is appropriate, but it's 10 years ago.
Yes, sir.
And has RC been incarcerated since these 10 years, or is this just new information that's come up?
I can't answer that. I would like to, but I can't. I know the answer, but I can't tell you. Anybody else? Questions? Yes, sir. 32.
Yes, in your homily here.
Yes.
You're talking about the charges that were brought by the DA.
Yes.
And they brought the first charge about multiple charges.
Correct.
Isn't that part of the DA's job is to bring multiple charges, and if they can't get on the first one, then they do a lesser charge and go down? Or is that not normally the?
No, you're right. They're supposed to charge with what crime they think you committed. My argument is just the more stuff I see, the more confident I am that they're really not sure what they can prove. So it's like, hey, leap with me off the high dive, or leap with me off the low board, but just leap with me. I'm skeptical of that. But you're right. Yes, they have to decide what they think they can prove. And I guess if they're not sure what they can prove, then they try to, it's like this throwing the spaghetti at the wall thing, right? But maybe something will stick. Maybe it won't. Maybe it all slides down to a nice pile on the floor. People that have been on a criminal jury before, were any of you the foreman of that jury? I think there were three or four of you. No, nobody was the foreman. Okay.
Civil.
You were the foreman of a civil jury?
Yes.
Okay.
Yes.
Also foreman of a civil jury. Okay. 18 and 26. I think, right? My numbers are right. Okay. 39.
7.
Yes.
Yes, you were the foreman of a criminal jury?
Yeah.
What kind of case was it?
I think it was criminal. It was a DWI.
Okay, yeah. Was that here in San Antonio?
Yes.
How long ago was that?
15 years ago.
Okay, and as the foreman, you oversaw the deliberations. You know the verdict has to be unanimous, right? Did you enjoy that experience? Honestly, I mean, I think it'd be cool to be on the jury. I'll never ever get to be on one, but
Yeah, so that, in fact, that's why I volunteered in that case to be.
Okay. And in your case, did the judge or jury assess punishment if punishment was necessary?
He did, so I don't know.
Okay. Okay. Anybody else? Okay. Questions for me? This is really about your last chance, or we're gonna have a jury of 74 people. Okay. Which would be fun, but not. Yes, ma'am, 16.
We can't ask specifics about the case.
I cannot tell you specifics about the case. All that you can know about the case is what's in the indictment. So that's as detailed as you can get at this point. And that's very fair, because if they got up to tell you their version, you know, hey, here's what happened. How do you feel about that? Well, they're asking you to tell us right now, you know, what are your thoughts about the facts without knowing the facts. And that goes back to what I said earlier. Just because they say it so doesn't make it so. The evidence doesn't come from Daryl and Steve. The evidence comes from the stand. And the evidence is only used if you believe it. If you're skeptical, like, let's say there's some DNA tests, and let's go back to my arm on the desk. And I mean, if the test results were like, hey, we found some DNA. Oh, maybe it wasn't DNA. Oh, yeah, it was DNA. Well, we're not really sure, but we're going to call it DNA. I'm skeptical, right? Those kind of things should give you pause. Should make you stop before you jumped off the cliff holding their hands. You can only use the evidence you find credible. If you think is important to you and credible. Thank you, sir. 71. How are you?
Yes, I'm doing great.
Good.
My question is that, I'm sorry about this, sir. My question is, you had a time frame of when this case is supposed to be over. Will it give you enough time to be able to get the evidence out that you?
Yes. I can assure you the judge is very fair, and she anticipates finishing this week, but if something happened and we needed more time, she's certainly not gonna not let us finish.
Okay.
Yes, sir. The judge talked about it, how RC doesn't have to testify. In fact, the law says we don't have to put on any evidence at all. In fact, that happens a lot. The state puts on their evidence. The defense pokes so many holes in it that it's bleeding like a head wound. And so the defense says, you know what? I don't need to do anything else. They've already done it for me. And the judge told you all the state has the burden of proof. The defense has no burden. And Mr. Curtis doesn't have to testify. And all of you said, hey, we understand that and we're good with that. I think a couple of people said, no, I want to hear from him. But most of you and the majority said, okay, we're fine. Did everybody understand that principle of law? I don't have to prove anything. Their witness can testify and I can convince the 12 people those were the worst witnesses I've ever heard. Read your expressions and go, yeah, we don't need to prove anything else. They've already not proven enough. The evidence I have, I can get out through their witnesses. I can ask the detective, hey, did you track somebody's phone? You know, if I think that's important evidence, I can ask those questions of their witnesses. Because they ask their witness questions, then I get to ask their witnesses questions. And most of the time, the defense, if he's thorough and decent at his job, that's sufficient. I will tell you the 3 last not guilty verdicts in Bexar County, there was no evidence put on by the defense at all. Just 36 people said, I'm not jumping off that cliff with you. 54. Yes, ma'am. How are you back there?
Really curious, why 10 years later? What has taken so long? When usually you hear 2, 3 years, maybe 4, but why 10?
I really wish I could tell you it's a great story, but I can't. I'm sorry, but if I tried to answer, he'd stand up, she'd yell at me, and I'd get put in time out. And
just one moment, Mr. Bonk.
Yes, Judge.
Neither side is allowed to tell you anything about what they think the facts are in this case. Does everyone understand?
Yes.
So you can ask whatever questions you want to ask, but if it is something related to the facts that people think is about this case, they're not allowed to answer it. Does everyone understand?
Yes.
All right, Mr. Bonk, you may continue.
Thank you, Judge. Number 29, you are a police officer for Windcrest, is that correct?
Yes, sir.
And you said you've talked to Daryl on other cases, not on this case, I would assume, but on other cases. Is that correct?
Yes, sir.
Okay, because of your employment, obviously I anticipate, I never know for sure, but I think that I know that there will be police officers testifying in this case. because they're brothers in blue, if you will you automatically hold them to a lesser burden and believe what they have to say? I mean, in other words, if a cop says it's so, since you're a brother cop, does that make it so?
I've seen both sides of it in my 24-year career, so there are cops that get stuff wrong.
Sure. Where were you before Windcrest, if you don't mind me asking?
Texas Alcoholic Beverage Commission.
Okay. Thank you, sir. And I agree with what he said. They get things wrong. They don't do things they should have done. They rush to judgment. That's an epic failure of the police department sometimes. Rush to judgment. It was him. How do you know it's him? Goes, I think it's him. Well, did you talk to anybody else? No, because it was him. Well, but jump off the cliff with me anyway. No. Any more questions? I'm about done. Yes, 60.
Just something you said earlier.
Yes, sir.
Like about like the pictures and stuff. That's probably something that I probably won't be able to probably look at it. So I don't think it'll be fair.
Okay.
Like for
Appreciate
either
that.
side.
I appreciate that.
And like about beliefs, just me, I just believe that we don't decide what happens. Like, you know.
Yes or no.
So that's just, and that's not gonna be fair for either side if I can. If like for me, my personal belief is God is the only one that determines who we live, die, or whatever happens to us.
Yes, sir.
And that's just on into that, you know, that, you know.
Okay. I appreciate that. Thank you, sir. And he's right. And like I said, I'm not here to sugarcoat it. The evidence isn't pretty. And you're gonna have to look at it, at least briefly, if nothing else. And listen to it, and make a decision on what you think about it. But I just want you to promise me that this man right here is gonna get a fair shake. Everybody good with anybody that last chance, if you feel like for whatever reason, if I've asked you or if I haven't asked you, if you can't be fair to my friend RC, please let me know right now. 59.
It's just, I am like with him too. I get very like grossed out with blood.
Okay.
So I don't think it would be fair for him. If
I appreciate
was
that.
Supposed to see something.
Okay.
And feel a certain way about it.
You don't think you can be fair if,
I don't
if the
know.
evidence required you to look at stuff like that, you probably wouldn't consider the evidence.
Yes, sir.
Okay.
I don't know.
I thank you. 75. Yes, way back last but not least.
Yeah, I feel actually the same way as the other two.
Okay.
Said, I think that would be very difficult.
All right. Thank you, ma'am. Anybody else? That being said, on behalf of RC and Lindsay, thank you for your time.
All right, ladies and gentlemen, I'm going to ask you to leave behind the cards, take your personal items with you, stand in the hallway because you are not excused, and we will call you back in and let you know who is going to be on the panel.